Good afternoon, everyone. You ready to get started? Good afternoon to those of you here in the room in Washington, D.C., and good afternoon to those of you dialing in from the West Coast and around the country. We have a great crowd here, close to 100 people in our conference room here in Washington, D.C., in Venable's Washington offices. And we have what's probably a record crowd for us in these monthly webinars of over 300 people on the telephone across the country. They're either here for it's a very interesting hot topic, or they just could not wait to see Ron and AJ get together for the first time to deliver a speaking presentation. But either way, we're excited to have you. It should be a great program. Today's program is entitled Preparing an Online Social Media Policy, the Top 10 Legal Considerations for Your Nonprofit. My name is Jeff Tenenbaum. I'm the chair of the Nonprofit Organizations Practice at the Venable Law Firm. And as you know, as many of you know, because many of you are regulars, this is part of what's going on 2 years now of our monthly nonprofit legal seminars and webinars that we host every month on a wide variety of nonprofit legal issues. You're always welcome to join us if you're here in D.C. for a complimentary lunch here in our D.C. offices from 12 to 12:30, and then we always do the programs from 12:30 to 2 p.m. This program is being recorded, and as many of you know, we post all of the recordings of our nonprofit legal webinars on our website. All of you who are registered for the program today will get an email tomorrow containing a link to the recording along with the streaming PowerPoint and other related handout materials. Feel free to forward that on to colleagues and others who may benefit from those materials. We did hear from a number of you that you never got the confirmation email from today, particularly those of you on the webinar. And I'm told that quite a number of those emails were never opened, which suggests a lot of them ended up in spam filters. So if you never got the webinar confirmation email, check your spam filter. The same for the email that will go out tomorrow containing the link to the recording and PowerPoint and handouts. And you can always find all of the links to our recorded webinars at venable.com/nonprofits/recordings and venable.com/nonprofits/publications for all of our articles and PowerPoints and other good stuff on different nonprofit legal topics. Today's topic is one that AJ and Ron and myself and many of our colleagues here at Venable have been speaking on and writing on for many years now. Yet it's a topic from a legal perspective and, of course, some other perspectives that never gets dull or boring or uninteresting. From the legal perspective, the law continues to evolve, continues to keep us on our toes. There continue to be new wrinkles in the law in this area. And what we decided to do today, since it's been a while since we've done anything for our nonprofit audience on social media legal issues, we decided to do a couple things. One, to kind of focus on online social media policies. And as we're going to talk a lot about today, there are different types of policies. Many organizations have more than one social media policy, maybe one tailored to their employees and employee use of social media, and one tailored to use by others, such as members and donors, supporters, etc. But what we also decided to do is, and that's why we have two of my colleagues from really different practice areas, but both who spend a lot of time in the social media area, is to kind of marry up the topics that AJ Zatola is going to cover with the topics that Ron's going to cover. So let me introduce briefly both of our speakers. Their full bios are in your handout material, so I'm not going to go through and spend time going through all the highlights of their bios. Both AJ Zatola and Ron Taylor are partners here at Venable. AJ's here in our D.C. office. Ron is resident in our Baltimore office. AJ is someone who I've worked with for at least 10-plus years of the 14 years I've been here at Venable. AJ's been an integral part of our nonprofit practice, working with hundreds and hundreds of our nonprofits in everything related to technology transactions, software licensing agreements, social media-related matters, and anything that kind of bridges together things like copyrights, trademarks, defamation, privacy. So many of the things that nonprofits get involved in from the legal perspective require all of that sort of expertise rolled into one. That is AJ, and that is why he's here today. So he's going to touch on things like copyrights and trademarks and defamation, privacy, trade secrets, advertising and marketing, raffles and sweepstakes, things like that. And then Ron, who is a very accomplished labor and employment lawyer, heads our Maryland labor and employment practice and also heads kind of our national OSHA practice, Occupational Safe and Health Administration. Ron is a very accomplished employment and labor lawyer who has spent a lot of time and paid a lot of attention to the social media space. He's written a number of our alerts that you may have gotten on recent rulings by the National Labor Relations Board relating to social media and employers. And these are rulings that, while you may be saying, well, but that doesn't really apply to us because we don't have a unionized workforce, these rulings apply to all employers, whether unionized or not. So they're things that we very much need to pay attention to, and they're very much kind of moving the ball in terms of what you can and can't do as an employer, and all of your organizations are employers in the social media space. So I think you're really going to enjoy what Ron has to say today. I want to preview a couple of our upcoming programs. Next month, April 16th, our program is entitled Public Policy and Politics, Compliance Tips for Your Nonprofit's Advocacy and Electoral Efforts. Terrific program by three of my colleagues in our political law and nonprofit practice who are going to cover kind of a wide range of topics stemming from lobbying tax rules to the Lobbying Disclosure Act to political organizations, Federal Election Commission matters, PACs. And it's a program that's deliberately geared to all different types of organizations, 501c3s, C4s, C6s. So whatever your tax-exempt category, this program will be relevant and applicable to you. I think it'll be a terrific one, and I encourage you to come in person or dial in. And then on May 14th, 2013, at least once a year, we're going to be devoting one of our nonprofit legal seminars to international related issues, perhaps more. We just did a webinar yesterday for in-house nonprofit lawyers on international trademark issues. In May, we're going to be doing this program on entitled as Nonprofits, that should be expand their global reach, 3 areas to focus on: tax, trademarks, and the Foreign Corrupt Practices Act. 3 of my colleagues who do a ton of work in that area with our nonprofits are going to be speaking to you in May, and I think it's a program for any of your organizations who are currently engaged outside of the United States or plan to be in the future, and that's most organizations these days. I think it'll be a program you'll very much enjoy. Today, unlike most of our programs, we encourage you to ask questions throughout. We have such a wide array of material that we need to cover, and what we found in covering this topic is that many of the questions that come up are likely going to be addressed, at least in part, later on in the program. So what we're going to do is ask you to hold your questions until the end, but I promise we're going to leave a good amount of time for questions at the end. So be sure to write them down so you don't forget them, and we'll leave plenty of time for your questions for AJ, Ron, and myself. For those of you on the webinar, here in the room, obviously you can raise your hands, and we'll repeat the questions for those of you on the phone. For those of you on the webinar, you need to use the chat feature on the webinar software. Those questions will come in to me at the laptop at the front of the room, and I'll pose those questions to our speakers at the appropriate times. I think that covers it in terms of preliminary remarks. Looking forward to a good program today, and with that, I'm going to turn it over to AJ to get us started. AJ?
Well, welcome everybody. For those of you here and those online, we have a pretty great presentation for you today. Our focus is going to be on creating a social media policy statement, but we're going to get there by first introducing you to some of the risks and issues you're going to confront. Admittedly, your use of social media is going to vary, and so not everything you hear today is necessarily going to be of grave concern to you, but all of these things are possible issues that could arise depending on your usage, and so give some thought to them, both from the perspective of an entity and the perspective of a user. So, what are we talking about today? Well, I think most really know we're talking about social media, all different forms of this, but by and large, its hallmark is interactive communication. And you're familiar with the names, obviously Facebook, LinkedIn, MySpace. These are some of the biggies, and many of which you might be utilizing now to be communicating with your constituency. But again, social media can take all different shapes and sizes, and so really any type of interactive communication forum, any place online where you create an opportunity for people to post information or content, you could regard that, so to speak, as social media. So 10 years ago, this would have been considered a message board. Today, you might be using your website or your social media page for the same function. But all of these things, so to speak, are social media. The laws here, by the way, are really going to be many, and they can be both federal, state, or even possibly local laws on occasion when you are dealing with criminal issues specifically. We put up this pie chart just because we wanted to give you a flavor of all the different types of laws that could have some impact on your social media usage and practices. You'll see here that we've got a number of things in the pie chart, and frankly, no one area necessarily is dictated as being controlling because, again, it's going to depend on your usage. But in terms of the types of things that you could encounter, all of the things that we presented here are the types of laws or those of which they have supporting regulations that could govern your social media usage. So we're going to give you a brief overview again of how we set this up and lead towards development of a policy statement at the end. So we're going to be talking first about the legal issues you're going to be encountering. I think the key message takeaway, if you haven't otherwise come to this conclusion, is that you currently have few laws or regulations in place that actually govern specifically social media. And so what the law has done is tried to apply existing laws that perhaps were drafted for some other purpose to this new media online platform. And so to a certain extent, the rule is it's the same as it always has been, except the platform's different. The Federal Trade Commission yesterday just came out with some new guidelines on advertising for the online space. And frankly, what they really said was all of our existing rules apply to social media and to these new social media platforms, or in particular mobile devices. And so when you're looking at these things, you don't necessarily need to be reinventing the wheel. Many of you have existing policy statements that can simply accommodate this new communication platform. This isn't a situation where you need to rewrite anything always just for social media. So we're going to be looking at this from two primary perspectives, and one of the ways we sort of identified is both an external and an internal usage. So to a certain extent, you have entity-level usage of social media, where to a certain extent your organization will be the face or the presence online. And here you're going to encounter potential risks along the line of defamation, intellectual property concerns, trade secret concerns, advertising or false advertising concerns, privacy issues associated with data collection, and certainly to the extent you engage some other type of promotional activity that includes perhaps a contest of some kind, those rules could apply to your organization. We're going to follow it up, and Ron's going to talk a lot more specifically about this with sort of employee use of social media. We get questions along those lines as well, and sometimes the question begins with, should I be treating the employees differently? Do the issues change? On occasion they do, but here I think we have more particular concerns about attribution, when an employee is acting on behalf of the entity. And second, when dealing with discrimination and harassment issues. And Ron's going to give you a lot of examples about this, but your policy statement can be used to define business and personal use, and how that is characterized can lead to whether or not, to a certain extent, your employee is acting on behalf of your entity. And then, of course, there's this notion of on and off the job conduct. To some extent, this is going to be very, very difficult to control. Organizations that have tried to clamp down on things too much have gotten themselves in more hot water than they probably needed to. But again, this is something where it might be worthwhile to define when the entity is acting, when the employee is acting on behalf of the entity. So we're going to start first with defamation. And in terms of what it is, I think the key takeaway here is, contrary to popular belief, not everything you read or hear on the internet is true. And so what is defamation? Well, by and large, it's the act of harming somebody through a false statement. This may seem obvious, but things to look for here are both a false defamatory statement, communication, which is your online social media platform, and then some kind of harm to the third party. Now, some of these elements are subjective in how they're determined, but clearly defamation is very likely or possible through social media platforms because of the nature in which things are communicated, not only just communicated to a very wide audience. And so you need to be on the lookout for instances where your statements can cause harms to others. Now, many of you are sort of representing organizations, so what is the organization's concern here? Well, we kind of look at it from two perspectives. Are you functioning as a publisher or as a distributor? Now, you may ask yourself, well, maybe both on occasion, and that could be true as well. But many of you join social media networks where the distribution function might actually be performed by someone else. Or you might make available a communication forum where you might invite others to provide content that you don't necessarily post or edit. And so you do have some control here over when you are functioning as a publisher and when you are functioning as a distributor. When it comes to defamation, when you are functioning as a publisher or distributor, that's where liability is possible. So the publisher who publishes the statement can be held liable. The distributor who actually repeats the statement can be held liable. And here, definitely, there's a situation where the comments can be attributed to the organization when said or made by your employee. So the notion of attribution to the entity is definitely something to be on the lookout here. So we told you what it is. We're going to tell you a little bit about ways to avoid defamation liability. And this is one of the few instances where you might have different treatment because the statement or communication was done online. Now, the act that we're noting here, 1996, so Facebook didn't exist then. So this clearly was not drafted for social media. But it was drafted for message boards, other types of online communication forum. And so our advice here is always to see if we can pattern your behavior after existing immunity opportunities. And so essentially there might be a way for you to take advantage of this immunity treatment for what was originally supposed to be someone like America Online who had a message board feature and apply that to your interactive communication pages. But this is only going to be possible when this information that is perhaps defamatory is published or provided by another. So I mentioned before the publisher-distributor liability. This is not an instance where you can claim immunity if you're a distributor or a publisher. We are talking about instances where you created an environment for communication amongst your constituency and then someone else provides the content. But in those scenarios, you might be able to claim outright legal immunity if you have some ability to control access and some ability to take down the content. And so your policy statement, this can play a role here because you can define both what is appropriate content and then also define the circumstances where you might take it down. Now, understand that we're not advocating that you edit or review every single piece of communication that goes up. To a certain extent, this immunity works better when you are not doing that because you want to suggest that you are merely providing the marketplace, as it were, for people to communicate, or the room. But you also want to have some ability to react. So think of this as sort of an immunity that's available for reactionary measures. But defamation, very likely to occur because people tend to treat social media as being more informal than other types of communication. I'm not sure why, because the audience can be in the millions or billions, whereas individual email can go to a very limited audience. But we have seen that people tend to think that it's somehow more informal. We'd advise you not to look at social media that way. Again, you're going to want to use a disclaimer or a policy statement here for controlling the content. You're going to want to have a takedown policy. So if a statement or communication is made that contains defamatory content, certainly not something you're going to be interested, most likely, in continuing to publish. You're going to want to take that down to the extent you can. Now, you may not have complete control here. Maybe your network operator does. But you can then, at least in that case, direct the person who alleges to have been harmed to the network operator. You know, this is how you have this removed from Facebook. You can't control Facebook or LinkedIn or MySpace, but you can certainly have a role in taking people and directing them to the appropriate place. Refrain from acting as an entity in commentary that is critical or someone could deem as causing harm. And so always be mindful of when you are posting information where it's supposed to be an official response statement from your nonprofit. Second, be aware that these are instances that the immunity applies to defamatory liability. It has nothing to do with trade secret misuse of confidential information. And so if that is what's being published here and the harm is some type of trade secret misappropriation, this immunity is just unavailable. And then finally, some hosts or network operators make available screening mechanisms. So trigger words cannot be posted, things of that nature. If you believe that that's something you'd like to utilize, then by all means, take advantage of available technical measures. Now we're going to move on to certain kinds of IP, and we have trademark, which are source identifiers. I think when it comes to social media, the key takeaway is that you can have trademark problems whenever you're using a third party's mark. Just because you might have tax-exempt status or you might function in some kind of charitable capacity has no bearing on whether or not you have any right to use the trademarks of another entity, particularly popular trademarks. So don't assume that you have any sort of fair use here when it comes to using a third party's marks. You always want to be seeking permission. There have been instances where someone has been calling us to see if they can get out of seeking permission when ultimately we directed them to seek consent, and it was freely given. So when you are using a third party's marks, if you have not received permission, the first avenue is to always ask and see if it's possible to obtain. They may not allow what you're doing, in which case you may need to use an alternative word or logo, or not use the logo altogether, but seek permission. Be especially careful in context where the usage is commercial. Now, there is a notion of fair use, but we tend not to advise people on the intricacies of that simply because they always assume that it's broader than it really is. And the notion of what can constitute commercial context or use is much, much broader than people think. You might be engaged in something that doesn't have some type of fee requirement, but the objective might have some indirect commercial benefit to you. That can be construed as commercial. And so when you're using third-party marks, you really want to be especially careful in instances where there's some kind of commercial context. Don't use trademarks and account names, account identifiers. There should not be any type of nonprofit that has Coca-Cola in its name. Now, the account process where you sign up is pretty much first come, first serve, and so it's possible to introduce trademarks into the account names, and not really much of a mechanism to put a stop to that until someone complains. But as a matter of course, you don't want people using the marks of others in account names. And in particular, you don't want them using them as a meta tag or domain name or usernames or anything that has some kind of search function. Copyright. So copyright, really, we're talking about any kind of work authorship that is a type of creative expression here. So in the social media world, I mean, essentially, this is it. Most of what we're talking about here is content that's communicated, content that creates, interactive communication. So to a certain extent, copyright is one of the definitive laws that governs, at least from an IP perspective, the social media world, because it's mostly about the content. When we're encountering copyright issues, what tends to be the biggest issue is who owns. Who owns the work? Well, the general rule is that the author owns. There are exceptions to this. There's the work for hire doctrine, and then there's opportunities to have rights transferred to you. The most common type of work for hire is a employer-employee relationship. When an employee is creating something on behalf of the employer is going to be deemed to be the author. There are other types of serialized creation when you're writing articles, but 9 out of 10 times you are either dealing with an employee who's created something on your behalf, or it's an independent contractor. And most independent contractor engagements that you will face do not have a work-for-hire component to them, which means that the only effective way to take ownership of the content that's being created is to have a written assignment. Copyright is the kind of property, like real estate, that requires written transfer. You must have a document that says, I hereby assign to you. So when you're thinking about the content that you're putting up on your social media page, and now more and more time is being spent on creating that content, you need to be mindful about who owns it. When it's done by your employees, you can take advantage of work for hire. And when it's done by a contractor, or when you're allowing members of your constituency to create the content for whatever purpose, you need to be thinking about whether or not you need to introduce an assignment in order to take ownership if that's something you want to have. Now, in terms of misusing content of others, it's possible that the same situations that can give rise to defamation liability can also give rise to copyright infringement liability. And it just so happens that copyright also has its own rule under the Digital Millennium Copyright Act that provides some measure of immunity. Now, again, this was not something that was created for social media, but try and pattern your behavior. And so this is almost, again, looking for sort of a independent status in the distribution or publishing role. So you can't be gaining anything from the publication of the content. You need to be aware of when someone has complained about it, but not have any kind of role in its publication or distribution, at least any kind of formal role where you're dictating when the content is being posted, and have a takedown policy. This policy that we're describing for copyright is different from the one that we have for defamation. And the copyright rules have more particular requirements about what exactly your statement has to say and to whom notices of complaint need to be given. But you do have an opportunity here to take advantage of available immunities for copyright infringement claims and also for defamation claims. You do this through having some type of policy statement or terms of use controlling what kind of content can be posted. And then, frankly, you need a separate takedown policy, a copyright takedown policy for copyright claims. Now, when would you need these things? Well, again, this isn't of no use to you if you're the one involved in publishing. If it's coming from your organization, from your employees, these immunities will not be available to you. But if you have an opportunity or if you've created an opportunity for people to post content, then something like this will be of benefit to you because you will be able to claim a legal defense and outright immunity from statements that were created by others.
AJ, before we move on to the next topic, just a couple side notes about copyright. There still remains much confusion and misunderstanding in the nonprofit world about this. First off, just because you're paying someone to create content for you, no matter how much you're paying them, if you have a written contract to create that content, software developer, someone who you're paying to write columns on your website or your newsletters, paying an editor, whoever you're paying to create content. If you want to own a content, there has to be something in writing that says, I, the author, transfer copyright ownership over to you, the nonprofit organization. It doesn't have to be complicated, it doesn't have to have any special magic words, but it does have to be in writing, and it does need to assign or transfer that copyright over to the organization. So don't make that mistake. Anytime you're paying someone for a service like that, you should have an independent contractor agreement in place anyway, and you should have standard language in your independent contractor agreement to provide for copyright assignment. Secondly, volunteers, members, donors, constituents. Many nonprofit organizations rely heavily on the contributions, the content contributions from their volunteers, and also from officers and directors and committee members and others. Again, because these are not employees, so that work made for hire doctrine doesn't kick in where the copyright is automatically transferred to the employer. Here, any non-employees are going to be governed by that basic rule of the author is the owner unless the rights are assigned over to the nonprofit. So it has become a best practice in the nonprofit world for nonprofits to get in the habit of having all of their volunteer content contributors click and accept or otherwise sign or agree to something that in writing that signs over, that assigns the copyright of their contributions, whether it's on a listserv or on anything else, over to the nonprofit. So then the nonprofit can then be sure that it owns all that content and it can do whatever it wants with it. It can cut and paste discussions from a listserv and post them on their website, put it in their newsletter, create new articles and other ancillary materials out of it. But you can't do that if you don't own the rights to that. It doesn't have to be complicated. It doesn't have to be a contract that's going to scare people away. You can use a click and accept feature, but you do need to get it in writing and get them to agree to assign the copyright.
All right. Moving on then to trade secrets. So this is information that, because it's been kept secret, creates some type of advantage, or because it's been kept secret, it has some kind of value. You have trade secrets whether or not you really regard yourself as being of the kind of company, like a technology company, that would have much value in it. But financial information, business plans, et cetera, all that can qualify as trade secrets. Social media doesn't necessarily create more opportunities for trade secret disclosure in the sense that you are going to be using that to provide information on trade secrets. However, you're dealing typically with a much wider audience through social media networks. Moreover, the opportunities for unauthorized or inadvertent leakage is far greater with social media because the opportunities to connect to these networks is just expanding. You have your PCs, your laptops, mobile devices, televisions. It grows every day, and so the opportunities for unauthorized or inadvertent leakage is far greater. And so trade secrets are largely controlled through controls or just not using the information. In terms of the kind of things that we've encountered on this front that could qualify as a trade secret, well, there are questions now as to whether or not the context that appear in someone's social media account will qualify as trade secret information of the entity. So you designate an employee to create a social media account for you. They more or less run your page, etc. They have lots of friends or other type of people in their distribution account. Does that page belong to them? Does that account belong to them? Is that information theirs? Some of this information would be subject to the copyright discussion we just had, but some of the information would otherwise be public, somebody's name, or too factual to qualify for copyright protection. And so when you're thinking about whether or not you can claim trade secret status in certain information, start to include your information related to your social media account. We would advocate that you should set up your official entity pages in the name of the entity. Don't give this to IT. Don't have a particular entity employee take control over this because they're more familiar, because there could be issues now about whether or not the account and all the associated information in it are owned by the employer or the employee. And also, to the extent you can use social media to disclose trade secret information, you need to be aware of any other third parties that are involved. Did someone give you the information with the expectation of confidential treatment? Do you need to use an agent and have them maintain confidential treatment? So when you're thinking about disclosure, think about all the people in the chain as well. IP protection. So this is instances now where you're trying to protect your IP, and you obviously want to be monitoring for use. Your ability to monitor will vary, but with nonprofits we've found that there sometimes can be, so to speak, entity drift, either because you have affiliated entities that use the same names or materials, or you just have people that like you and want to use the same information and materials. And so in certain instances, some of this may be appropriate, and others it might be deemed misuse. And so you want to be keeping an eye on both your official presence as well as how your information, names, etc., are being used. If you ignore these things, it can give rise to enforcement problems down the road. But when you are called upon to enforce, a lot of times in this context, there is innocent infringement. They want to promote your message. They are in agreement or in alignment with your objectives. And so don't necessarily assume that enforcement here means that we're called in to write nasty grants, or maybe we have to be. But sometimes simply alerting people to appropriate use of their IP is the remedy. So telling them that they need to do proprietary notices, using appropriate symbols. Sometimes this is enough to alert people to proper use. But again, you're enforcing this through policy statements, through your takedown policy, the Digital Millennium Copyright Act takedown policy. When necessary, demand letters and certain legal proceedings, but you can try and use that as a last resort. And when we're focused on IP protection, your best protection is to see if available protection is available through a registration system, because that gives you rights to enforce later. So your trademarks, your copyrights, we're not talking too much about patents here simply because social media, at least in terms of your role involvement, doesn't tend to implicate it quite as much. But if something can be registered to bolster your rights, you should be thinking about that in advance. Misleading advertising, in this case, most of you are not engaged in promoting, consumer products or services. So we only wanted to bring this to your attention to remind you that when you are engaged in advertising promotion, the FTC is not going to treat the social media page, advertisement, etc., as being any different from any other kind of advertisement. So to the extent you need to have necessary disclosures, any disclaimers, etc., all that needs to be in the social media ad, because all products and service claims, all promotions, etc., are going to be considered advertising as far as the FTC is concerned. Where this has become an issue is when you have somebody who is providing some type of endorsement for whatever topic, and they are not providing that endorsement with the necessary disclosure or notice of their connection to the entity, the message, the objective that they're endorsing, bloggers, etc. Behind the scenes, there may be some underlying connection that needs to be disclosed, maybe doing this for payment, etc. The FTC is mandating, this is mandated, that when you are engaged in this kind of activity, you need to be ensuring that the advertisements certainly are truthful, but that when this endorsement is on your behalf, that you provide notice of the connection. So if you have an actor who's advocating or otherwise promoting your efforts, otherwise speaking on your behalf, some notice of that connection needs to be there. And again, try and think about this for people who are bloggers or industry voices who tend to comment about what's happening in the space. If they are in agreement with what you're doing, you need to be careful about what they're saying about you, even if it's positive, because there may be a need to sort of treat it as a type of advertisement for your benefits.
And think broadly about this too. It's not just your own commercial type products and services that you might be selling, but it's your own membership in your organization, conference registration, exhibit sales, advertising sales, and it's not just products and services that your organization offers. It can also be, we see this a lot in the nonprofit context, it can be for-profit companies' products and services that you endorse, affinity programs, things like that, where there's commercial products and services that you are recommending to your members. Maybe you get a percentage of the sales in exchange for their right to use your name and logo in connection with the marketing of the product or service. And if you are making comments, claims, endorsements about those products and services online, these rules are going to kick in there too. FTC, Federal Trade Commission, does not have jurisdiction over bona fide 501c3 organizations, but it does have jurisdiction over 501c6 trade and professional associations. And certainly if we're talking about, say, an endorsed for-profit product or service, the FTC is certainly going to have jurisdiction as well.
Moving on to privacy, in the United States, there really isn't a true right of privacy in the sense that it might exist in other parts of the world, particularly Europe. But there is a notion of fair trade practice when collecting or using personal information. And so to the extent that you use your social media activities or pages to collect personally identifiable information, name, address, phone number, etc., know that, again, here there's increased scrutiny on how that data is being collected, and in particular how it's being collected through mobile devices, simply because to date there has been little in the way of disclosures made over what kind of information is being collected through a mobile device. And so for your activities in which you might collect information, even if it's intended to be innocent collection to facilitate a meeting, a program event, etc., if you're asking for anything that constitutes PII, you should be aware of the need to have a privacy policy statement applied, just like it would on your web page. What's easiest administratively is to try and keep things consistent. So you don't necessarily need to invent a new policy statement online, particularly because maybe you're not doing anything differently. But if you can make use or reference to your policy statement, then by all means try to do that. Now, the rules as to what type of disclosure or notice is appropriate continue to be under review. And in certain contexts, there just isn't enough screen real estate to provide a full notice that you could have on a web page. And so how much to say? I'd say that's still under review, but at a minimum know that you need to have perhaps some kind of notice when you are collecting PII. And in particular, when you are collecting it through advertisements and when you're collecting it through applications that you might have. We've worked with a few folks who had a program event come up. So they invented an app just for the program event, where they would have information on the event and about the meeting and the attendees, et cetera, and there was ways to communicate through that app and also to provide information to participants or other people who were there. I mean, you were engaged in information collection, and so always be aware that you need to have a privacy policy. Now, with social media networks that you might join or participate in, know that they likewise have privacy policies, and those policies apply certainly to the network, but they are not your policy statements. So LinkedIn, MySpace, Facebook, their privacy policies are for them. Your privacy policies may differ. In fact, I would suspect most of you would collect or use less information than most of the network operators. And so be mindful of those policy statements being there, but understand that they're not for you. They're for them. And again, you want to be mindful of keeping everything administratively the same to the extent there's overlapping usage. What I'm talking about is you pull in information from one source, use it in another. If that is possible or likely, then you need to be keeping your statement about how you're collecting the information and how it's going to be used similar. So if you tell people in one context, we're never going to give it to anyone else, you can't give it to someone else in another context. Most of this information comes in, it's stored in a standardized account. And so when we tell you to keep things the same, it's going to be easier for you to administer this than if you suddenly think of social media pages, because there's less real estate there, as having some kind of different policy statement. Again, try and be consistent. Promotions and contests, this is not an area for which we can give you a full review, mainly because it is state law driven and the states tend to vary. But the things to keep in mind is when these kind of rules can apply. And so think about instances where you might have some type of game opportunity. So sweepstakes in this case, we're talking about instances where the prize is given away through luck. Contests, there's some type of merit or skill involved, even if it's minimal. And then there's lotteries. The lottery requires payment. If you have anything that fits within these categories, for whatever reason, you need to be aware then that there are rules that apply. Some of these things can take place without further registration or other notice requirements. Some of them absolutely cannot. In particular, there are very strict laws on lotteries. And you need to be aware of the fact that not only do the laws apply, but all the network operators are likewise concerned about having lotteries that violate law show up on their network pages. And so Facebook in particular has rules on when you can have a promotion, contest, sweepstakes, etc., that you likewise need to comply with above and beyond what the states require. And so whenever you have anything that has the following elements, some type of payment, some type of chance opportunity to win, and some kind of prize, you might be dealing with a lottery, in which case you are very likely going to have to register that lottery with the appropriate state official. Simply requiring even a donation is frequently considered to be a lottery for this purpose. And so the takeaway here is that when you're involved in some type of gaming opportunity, and people love these because it gets a lot of people involved and they're fun, know that there could be additional requirements and that you will have to comply with those requirements both within the network and externally with state or federal rules.
Well, by now, all of you probably fall into one of three groups. One group of you is probably rechecking Jules Verne's math to see whether you can really create a time machine to take you backwards. There's probably some of you who are thinking about the story, whether apocryphal or not, attributed to Harry Truman, where somebody came in and said, Harry, you really give them hell. And he reportedly replied, I don't give anyone hell. I simply tell them the truth, and they think it's the hell. Or you fall into the third group, which is willing to embrace all this new modern technology, but are beginning to perceive that it's a little bit more complicated than it seems. And I use that last one first because that's a lot of what employment law is. Employment law in the United States is deceptively simple, yet all of the things that AJ said and all of the things that Jeff said apply. Your employees are a potential source of liability because the things that they say or do on the social media or on the internet could create potential liability to you, whether they're trashing the competition or they're posting Larry Flint's latest pornographic pictures or whatnot on your website. So they could be potentially creating liability, or they could be creating liability because they're doing things that violate your policies and violate other federal, state, and local laws relating to how employees are supposed to be treated. And we all know that there is no bound to the imagination of employees and the plaintiffs' lawyers who represent them when it comes to trying to sue nonprofits and other employers such as yourselves. So what I want to do is not go through and become a primer on all the aspects of employment law. I assume that you all are somewhat familiar with it. But again, to the point that AJ made earlier, talk a little bit about and try and identify some of the risks that a social media policy presents to you so that you can assess the risks from your employees to outsiders and the risk from people outside potentially creating to your employees. Again, the use of a policy like this requires you to think through a lot of things, and a lot of what AJ and I have been trying to do today is to issue spot. This is what law schools teach lawyers. They don't necessarily tell you all the answers, but they help you to identify the issues, and sometimes you have to go back and dig more deeply for that. A typical concern, of course, as both AJ and I have said, is the concern about this is your website, or this is your Facebook, or this is your LinkedIn site, and what goes on there either is put up there by you on purpose, or alternatively, by you allowing it to continue to stay up there, you in essence are ratifying it or condoning that activity, and all those sort of things can lead to potential liability for you. Of course, whenever you have employees posting information, they may post your secrets, and it takes a long time to develop the protections for a trade secret or other confidential or proprietary information, which is generally designed or defined as information that is not generally known to your competitors and would be useful to them. And that applies with the same force whether you are a for-profit company or a not-for-profit company. And so the concern about an employee putting something up and then losing it is something that is very real, because once lost, you're never going to regain it. If you think that the comments that AJ made about ownership are a little bit pie in the sky, we included this next slide here referencing this case, Eagle versus Morgan. The employer is actually a company by the name of EdCom. It shows you just how complicated this is. EdCom had a policy that was using LinkedIn, and this woman was an officer of EdCom, and she created a LinkedIn site for herself, had her name, listed her job title, and she used it both to advertise herself as a professional businesswoman as well as the work she was doing for EdCom. So it's sort of a dual purpose thing. When she was separated from the company, EdCom immediately took over her LinkedIn account, changed the name, and set it so that it would be anybody looking for her would be immediately directed to her successor. And that's actually who Morgan is. Morgan is the person who replaced Eagle. And she filed an 11-count lawsuit saying that they had stolen her property, that they had invaded her privacy, misappropriated her likeness, misappropriated her business name, had interfered with business opportunities to the tune of at least $100,000, that she had defamed her so that she should get reputational damages, again, invasion of privacy. 11 counts. The federal counts were dismissed, but the case proceeded on all these other counts. Very significant potential liability based on the claim that she owned and had improperly been hijacked of her LinkedIn account. And so the notion that you have to think these things through is something that really needs to hit home with you, because to the extent that you don't have appropriate protections in place, it could redound to your detriment later. A very typical complaint, however, is the concern that people are posting inappropriate information on a Facebook or other type of social media. I presume that most of you, if not all of you, have some sort of policy that prohibits employees from disseminating pornographic pictures or movies and things like that, video clips on the computers. Everybody probably has a computer policy. Well, this is an extension of it, because the kinds of things that employees may post on this could lead to claims that you're condoning or making or living with harassment in the workplace. Yes, sir.
Is the proper date reference?
That is not the proper date reference. That's actually October 4, 2012. So it was last fall. So there are concerns about recruiting, hiring, concerned about whether or not you're condoning what would be workplace harassment, which would be discrimination or offensive conduct. For example, if you were having people posting, I had a case once involving a fellow who had a tattoo on his arm that was a noose with a Southern flag, and it said Southern Justice underneath of it. So you can imagine it's incredibly offensive. To people posting things like that, if you don't have the sort of policies that AJ's already talked about and continue to have that up there, you're going to run the risk that you are going to be sued by a significant number of people. Again, the same thing with references. This is a particular issue with respect to LinkedIn. Most of you have a policy, I presume, that says references have to come through a specific person so you can control what can be said. You do that because you don't want to be potentially sued because you're saying great things about somebody who's a problem. For example, a child molester who wants to get a job at a daycare center. You're not going to say, we think he's a perfect employee to work there. Conversely, you don't want to be saying information about people that is demonstrably false and is going to prevent them from getting a job because what you're saying about them is potentially defamatory. So most of you control that, and most of you probably, like most not-for-profits, have a policy which provides a neutral reference, which is in essence name, rank, and serial number. So there's a concern there. The biggest, hottest topic right now, however, has to do with what you have to let employees say. And it comes back from a law that was passed in the late 1930s, the National Labor Relations Act, and it's the statute that allows employees to engage in concerted protected activities, activities that are of mutual concern relating to hours, wages, other terms and conditions of employment. It's the law that authorizes employees to join or not to join a union. And with union membership in the private sector hovering at about 7%, many people think that unions are irrelevant. That's certainly not the case, and it certainly hadn't been the case in this administration. And what we have seen more recently is that the National Labor Relations Act, the federal agency that administers this 80-year-old law, has reasserted itself in areas, and it's had a significant impact on employers in the private sector. Things that you thought you wouldn't have to put up with, now you might have to put up with. And I'll go to the next slide and talk a little bit about it. If I can get this thing to change here. Oh, I'm sorry. There we go. Forgot I'm looking at one in front of me that's not going. So I mentioned the National Labor Relations Act. All employees who are not supervisors have a right to engage in this concerted protected activity. I've included some of the significant cases, but typically the cases involve people who have policies that are overbroad, and an employer has said, you criticized a supervisor or you criticized another employee, and I'm terminating you because we have a policy that says that you can't criticize or you can't harass other employees. And that's been determined to be too broad. A typical example that I see from many employers, including many nonprofits, is that they have a policy that says that you may not talk about your salary or your wages with other employees. That is a policy that on its face is illegal because employees have a right to talk about wages, hours, and other terms of conditions. And so the National Labor Relations Board, when it looks at written policies, looks at them and tries to decide whether it will chill an employee's ability to exercise his or her rights. And the way they look at it is sort of twofold. First, does the employer's policy expressly restrict a right that is protected? For example, do not talk about your wages with other people. That expressly restricts their rights, and that's an illegal policy as far as the National Labor Relations Board is concerned. The second way that they look at it is, would an employee reasonably construe it to limit his or her ability to engage in protected activity, even if it doesn't on its face expressly talk about something that is protected? So, for example, the case in which you may not criticize another employee or you may not criticize the employer, there have been any number of cases in which the National Labor Relations Board has held that that is overbroad because it will tend to dissuade employees from engaging in activity that would be otherwise protected. And so the way in which you write these policies is fairly significant, and there's some rules down at the bottom of this slide that you can see. An activity has to be concerted, meaning that it has to be something that involves more than one person's individual gripes. The problem with a social media page is that you may not know that. So when a supervisor comes into you and says that Susie has just said bad things about me and I'm really upset with it, you can look at the Facebook to see if other people have followed it, but you may not know because you may not see it or you may not know exactly what it is, and then you turned out you take an action, and then you find out that you have engaged in something that is illegal. Not only is there some leeway there, but employees have been allowed to say things that would otherwise be intemperate, to call people bad names. And the National Labor Relations Board says you have to give them a little bit of leeway. So what you're going to see in this developing area is that you have to use a little bit of caution before you discipline somebody, because the National Labor Relations Board is not reluctant to step in and come in behind and say that you should not be doing this. So you need to think about that. We're going to go through what AJ and I are going to try and do is to go through and actually talk about some of the considerations and tie these points in terms of how to help you to write a policy that is going to protect you from litigation, protect your intellectual property, protect you against claims of defamation, and then also protect you with respect to your ability to discipline employees.
We'll do questions at the end because I'm sure that you have many. So we're going to now talk about developing the policy. You've heard a bunch of risks and issues that you may or may not encounter. So how do you go about drafting something? I think the place to start is to take a look at the network operator's policy, not so much because you want to pattern your policy after it, but you need to be generally aware of what it says so that you don't say something that contradicts that policy statement, because they are the network operator. They dictate the rules of the network in which you operate. So, for example, an easy one would be if you cannot engage in promotion, sweepstakes, or lotteries, then you can't have a policy statement that says otherwise. Second, when you're drafting this, we always encourage you to involve a multi-team approach, people from different parts of your organization, certainly legal, but also marketing, executive-level folks, HR. I mean, everyone has a different view or concern. They should all be involved in the drafting process. The next thing is give some thought to how you're going to be able to manage your presence online. What kind of monitoring can you engage in? If you can't engage in much, then that needs to be something you need to think about in your policy statement, because then you need to at least allow for more to occur, or perhaps your presence online should not allow for much to occur. Perhaps you need to remove some of the interactive capabilities of a page. Try and maintain a consistent approach as we recommended across your platforms. If you have a certain kind of approach through your own website, you really should see if you can take the same approach and apply it through the social network media page to the extent the functionality can be the same. Consider the shelf life of archived content. The bottom line is that things can be archived in perpetuity. We recently received, one of our clients received a complaint over a misuse of a photograph that was from 2009, which they don't even use anymore. But the complaint still stands. They're seeking licensing royalties, granted not too much, because the photograph can be found through an archive page. Everything is stored. It's available somewhere. And then finally, when you're drafting your policy, you need to give some thought to how you're going to communicate it. And also bear in mind that you probably have existing policy statements that can be applied to this. So don't think that this needs to be something where, again, you're reinventing the wheel.
So what do you do when you write a policy? One of the most important things that you can do is try to be as specific, as clear, and as concise as you can be, and avoid sort of blanket rules that are vague or subject to differing interpretations. A very recent case involving DirecTV makes this sort of clear. One of the things that DirecTV's policy did was they don't disclose confidential information. And the National Labor Relations Board, looking at this policy, found broad sections of DirecTV's social media policy to be illegal because it said, don't contact the media. That's too broad. Employees are allowed to talk to the media if they've got complaints about the employees. It'd be permissible to say don't contact the media and represent that you're speaking for the company, but to say generally that you're not allowed to contact the media without getting pre-approval is too broad because employees have a protected right. Don't disclose company information. That was too broad, and this was a case where DirecTV had not dovetailed it with its other policies because in its handbook, confidential information and company information included employee records, including information about wages and disciplinary reviews. And again, that's one of these things that wages, hours, and other terms and conditions that employees are allowed to talk about. So you want to be clear and as concise as possible. So it's illegal, for example, say, please don't post information critical of other people based on a protected characteristic such as race, sex, religion, national origin, things like that would be permissible because you're tying it in with other federal statutes, and it provides a level of clarity that employees understand is going to be consistent with your existing policies as opposed to don't say something critical, which the National Labor Relations Board, at least, is likely to think is going to be too much. It's okay to require compliance with your rules. You just need to make sure that they dovetail. Focus, I think, for clarity on what you can do and what you shouldn't do. I think it's important, and this goes back to both what AJ and I have both been talking about, to create some sort of a reporting procedure. If you've got somebody on the outside is concerned, it's important to have somebody to direct them to so that they can get their concerns addressed. And it's just like your HR policies. If you've got an employee who has a complaint, you want him or her to go to somebody so that it can be resolved before it becomes a much bigger issue and becomes much more difficult for you to take care of. That requires you to think, just as in all your other policies, of a framework. How are you going to handle these complaints? What is the procedure? And so it's more than just having a policy. You have to think about how it fits in with your other existing procedures. And I think it's important for, in a way to save potentially ambiguous policies, is to say that nothing in this policy is intended to prevent you from engaging in activity that's protected by the National Labor Relations Act. So if you have a reasonably clear policy, and then you also have a statement down here, a savings clause or a disclaimer that says that don't misread this for what it's not. If you have a complaint that's protected, you may still do that. Then I think that is going to put you in much firmer ground, at least with respect to employment law considerations. I won't dwell on the implementing, but as in any policy, it's important that you tell employees what your rule is, tell them what the consequences of breaking the rule are, and then enforce them even-handedly. And your policy in this area is no different.
So what are some of the things your policy should include? Well, oftentimes we're being asked that you would like to have a policy that will allow people to actually engage in some kind of communication on an online social media network. One of the key concerns you need to be aware of then is limiting apparent authority, protecting your identity, okay? This is an instance where you're designing a policy so that the entity can communicate on its own behalf or allow an employee to communicate on its behalf. You must limit authority on who can speak on behalf of your entity. You must dictate when they are permitted to do so. That means that your policy statement shouldn't allow everybody to do it. There may be instances where that's appropriate, but most cases there are only particular people in particular contexts that are permitted to communicate on behalf of your entity. Be very aware of when you are using your identifiers, your names, your trademarks, your copyrightable works. If you are going to allow someone to make use of those, then have limits or at least some control over that. So this gets into allowing people to register an account using the name of your entity, or perhaps registering their own account using the name of your entity. And be mindful of allowing others to use other parties' names, identifiers, etc. We see this most often in instances where there's some type of local or state or national level connection, and perhaps the entities themselves are completely separate entities, but they're using the same names and there's confusion. So keep that in mind when you're drafting your policy statement.
And one additional comment here. Think broadly when you think about what AJ is saying about limits on who could speak on behalf of the organization, putting controls on it, requiring authorization in certain instances. Certainly it's easy to think of it in the employee context. You might have just a handful of employees who are allowed to speak on social media on behalf of the organization, to post things. You might have a prior approval process for certain of those individuals or all of those individuals. But it also involves volunteers. Just because someone is your elected president or chairman or vice president or vice chair doesn't mean you want to give them unfettered authority to go out there and act on behalf of the organization. We've seen way too many instances where volunteer leaders, and you all know, go a little bit too far and get a little bit too excited and say things perhaps they shouldn't have said. And so consider having kind of a framework in place for review and approval of comments by your volunteer leaders, whoever they are, before they can speak on behalf of the organization. And like AJ said, chapters and affiliates, this is a huge issue, particularly when like so many nonprofits, you share the same name and logo or variations of the same name and logo, and whatever your chapters and affiliates may be saying may tie back to you as part of whatever sort of license agreement you have in place with anyone who you're letting use your name and logo. Think also about the ability to use that on social media and what sort of controls or limitations you may need or want to put on that.
To Jeff's point, it's important to think about your intellectual property and to be cognizant of the fact that you need to take appropriate steps to protect your intellectual property, or courts won't do it for you. And so you need to put into your policy appropriate restrictions to ensure that your trade secrets are not inadvertently or deliberately, because you're not paying attention to it, disclosed to people and hence lost. You need to think about, for those of you who have restrictive covenants or non-solicitation agreements in your contracts with any, whether it be an executive or other employees, to make sure that your policy on your social media page dovetails with your policy that's in your contract. There are some issues. There's been a couple recent cases. What happens when somebody posts on their Facebook page that they're now employed not by your nonprofit but by another nonprofit? And so this is seen by a whole host of people, and they now know that Susie's not here, she's there. And that was an issue in a case that was just recently decided in January of this year, and the court looking at that said that that was not an impermissible solicitation. The reason is, I think, pretty clear. It's like advertising in the phone directory as opposed to a directed solicitation of somebody. And the court said that's just a posting. Anybody can look at it. They're not trying to target people, so that's not really a solicitation. There was another case that came out in October of last year that followed along essentially the same lines, where a person was friending people on a Facebook page this time, and the court again said friending is not a solicitation, although query whether it doesn't have necessarily the same sort of effect. So you need to be cognizant that the law in this area is evolving. AJ mentioned that when in the pie chart, that I think was the third slide that we presented here. The courts are still grappling with these issues, and people are coming up with them. The best thing you can do is try and think about this proactively beforehand so that you are best positioned when one of these claims comes up.
One final comment. Confidential information doesn't necessarily just mean pricing strategies and financial data about the organization. We had a nonprofit credit counseling agency client who ended up having to terminate 7 of their employees for disclosing confidential information about clients who they were counseling on the telephone, confidential information about those clients and their financial situation, posting on Facebook information about this particular client, kind of joking fun at them, things like that. Obviously clearly inappropriate, clearly a violation of their policy. But when we're talking about confidential information, think broadly about what that means.
Your policy statement should protect privacy and prohibit the ability for people to post disparaging or false information. Now, it would be easiest to say, let's best address this with absolute restrictions, prohibitions on doing any of those things. But sometimes those types of statements in your policy can trigger other laws, as Ron's been explaining. And so one other way to approach this is to think about what you'd be doing in the real world. And the easiest way to visualize it is ask permission. You want to talk about someone, you want to reference someone, post a picture, etc. You don't have authority to act on that individual's behalf. You need to seek the individual's permission. In terms of references, you need to be involving your HR department, the appropriate person, so that there isn't a likelihood for creating some type of disparaging or harmful statement as a part of the reference. But again, saying that these things can't occur usually will lead you into trouble. And so I think a more reasonable approach is to have some notion of a limit or to direct people to follow the protocols that probably already exist in other contexts.
And in terms of seeking permission and with respect to the right of privacy, you may say, well, every time we post a picture of people who are attending our conference or something like that, or we're going to tweet out photos during the conference, do we have to go to those individuals and get them to sign something to give permission? Of course, that's not practical, but there are ways to deal with that proactively up front by having, say, all registrants for the conference as part of their registration application agree to certain conditions, such as that they give the right to be photographed, videos taken, and for the organization to use that for whatever purposes that they want without having to seek consent. So think proactively about getting that sort of consent and release up front so you don't have to deal with it later.
So we're going to speed up because I know you guys might have some questions. So in terms of other elements of your policy statement, again, you want to prevent unlawful conduct. I mean, this is one of the easiest ways to institute some type of control. If it isn't lawful, then no one should be engaged in it. So one of the ways to define some of the things as a restriction is to say that you can't engage in things that constitute illegal or unlawful activities. And so you don't necessarily need to get into the process of trying to define when something might be obscene or defamatory, because there is an element of subjective opinion about these points. So One other way to approach this is certainly if the context doesn't allow for that kind of content, then make clear that the content is only for certain kinds of content. That's easier to describe sometimes than telling them what they can't post, because then you can simply say it's not appropriate for anything else. Or another way to approach this is to say that you are not allowed to post anything that's simply unlawful.
And so, sort of to wrap up on this, I'm not going to gild the lily that AJ has laid out in front of you. It's important to note, and you probably know this already, there is no constitutional right to privacy in the private sector. The right to privacy is vis-a-vis the government, and so the right to privacy exists only if you allow it to exist. That's why many nonprofits have policies that say that we're going to monitor your computer, we're going to look in your handbags, or we're going to check some other aspect. We're going to conduct alcohol and drug testing if you do that. And the reason that you have a policy like that and communicate it to employees is so that they do not have an expectation of privacy. If somebody is allowed to lock their office, lock their desk, then you're creating an expectation of privacy. And so just as you do with your computer usage policy, with your social media policy, you should have appropriate disclaimers out there or notices to employees saying that you will be looking at this information and that their use, particularly if it's on your nonprofit owned computer, is going to be information that is going to be available to and looked at by the organization so that you reduce any expectation of privacy and avoid the kind of claims that the woman made in the Eagle versus Morgan case that I talked about earlier. Now, there are some states that are imposing some limitations on the use of an employee's private passwords. Maryland, Illinois, and California have already passed statutes to say you may not require an employee to provide you with his or her personal account passwords. There's some expectation that the federal government is going to pass a similar law.
Ron, do you want to comment on, it's clear that when you're talking about, say, a nonprofit-owned computer on the computer network in the office, that clearly the organization has the right to advise the employees that anything on there is subject to search and inspection at any time without prior notice by the employer. And if we're maybe talking about, say, an employer-provided, BlackBerry or iPhone like we have, you would think the same ability exists. Does it get more complicated when we're talking about home computers, home laptops, home PDAs that people purchase and pay for monthly on their own, but they are using to maybe access the office network and to be able to do work from home or remotely? Do you have the same general ability to notify, and should you notify employees that any work that's done on those sorts of devices is subject to inspection as well?
That is a loaded question, but it's a very great question.
I knew that.
My general answer would be this: to the extent that they are using a home account, they're telecommuting, for example, or you're giving them access to your nonprofit database, I think you have the same right to control. You should tell them what you're going to do. It's always difficult to decide how far you want to reach outside the workaday world to reach into a person's private life. The general rule is that if I murder somebody, I'm going to get fired because nobody wants. I'm going to be in jail for one thing, so I'll get fired for absenteeism. But the notion is that all employers regulate a person's private conduct off duty, at least to the extent that it's going to cast aspersions on the company or on the nonprofit. So that's okay. In the private sector, that's perfectly okay. The general rule, employment at will, you can fire people at any reason for any time as long as it's not an illegal reason, and so that's okay. So the notion here is that you need to control, and it's permissible to control, off-duty conduct to some extent, particularly to the extent that it creates potential liability. What's a simple example? All of you know, two people go on a business trip. It's after hours. They go out, they have dinner, and one hits on the other person or perhaps makes unwelcome sexual advances. Is the company or is the nonprofit off the hook because that occurred at a business meeting in Laguna Beach after hours on a Saturday night? No. It's no different. You're potentially liable because you're still managing that employment relationship. So to Jeff's question is, if they're accessing your file and you're doing something, you have a right, and you probably should, make sure that they are still complying with your policies, even though instead of sitting in your office, they're sitting at home.
Okay. Thanks, Ron. Are we at the stopping point now for questions?
Yeah, we have some time left for questions. I figure there will be some. So I think we can take
questions from anyone in the room. We have a few on the webinar already as well. Let me, well, this is really one that Ron just talked about. All of our devices, business-owned and personally owned, seem to be linked now. Personal cell phones, home computers, and personal laptops are linked and used for business purpose instead of personal uses. I mean, Ron, if I can kind of echo or repeat what you just said and make sure I understand it. Certainly any conduct, whether it's on an employer-provided network or not, if an employee is on their home iPhone at night on the weekend and posting, inappropriate messages on the nonprofit's Facebook page or using social media to say anything inappropriate that reflects badly on the nonprofit, clearly that employee can be disciplined and even terminated perhaps for that conduct.
Subject to some of those nuances from the National Labor Relations Act
right.
that you'd have to think about. So it's clear as mud, yes.
Right. Obviously, if they're saying, all the employees need to rally up and fight these oppressive work conditions, that's a different story. You might not be able to terminate for that. But my prior question really got more to the monitoring issue. What right, because we're focused here, this session is about policies. And so is it, as a general rule, do you advise your clients that in their policy governing employee conduct that you advise employees that virtually any electronic device that they use to do their work or that has an impact on work is subject to search and inspection at some point?
To some extent, I would say yes. I mean, and it gets tricky because a lot of employees will get their nonprofit or their employer-provided BlackBerry or Droid, and then they will load all of their personal contact information into it, and it actually becomes an issue when that person is separated. Then they want all their contact information back, and you have to figure out a way to purge it. Better to think about it beforehand. I do not think that you have a right indiscriminately to go into somebody's purely, personal stuff on their home computer. I think you have to have a tie to what they're doing that affects the job. I wouldn't try and reach into, are you paying your bank account on time?
And that's a very good point, that you might want to have in your policy a pretty broad right, because as you pointed out correctly, if you put employees on notice that those things are subject to inspection, you eliminate any claim that the employee had a reasonable expectation of privacy in that material. That doesn't necessarily mean you're going to utilize that unfettered right, and you always want to check with counsel before you start inspecting employees' computer for many reasons, some of which you touched on here today. Another question from the webinar, and this is more for AJ, should takedown policies be public? If so, what level of specificity should be provided on the triggers? I worry with very specific triggers of possible harm with policy compliance inconsistencies.
The answer here is pretty simple. They actually have certain requirements that must be followed. In the case of a takedown policy, it absolutely must be public, at least in terms of copyright claims. It should be separately available and easily locatable, and in terms of what to do, you are basically a recipient of the claim. And if the claim has certain elements in terms of identifying reasonably the nature of the work that's alleged to have been infringed, where it's located, and the fact that it's located in something that you can control, then if those elements are met, you need to take down the work. Now, in response to that, though, and this is also something that's a part of the rules, but something that often gets missed in certain takedown policies, you should follow up with the person who posted, because on occasion, the person who posted had some right to post. Now, your situation is probably not going to be the same as others where there have been instances found where the person alleged to have violated a copyright actually had a lawful right to post information. But your policy needs to look for certain elements in terms of what constitutes a valid complaint, then follow up with the person or entity who posted, and if they don't respond with any kind of valid defense, then you can just assume that it's right to take it down. If they do, at that point it becomes a little bit more complicated, but you certainly want to move yourselves out of the picture. So if you find yourselves in a situation where you have two people with competing interests or claims, at that point you probably need to call an attorney, but certainly your policy statement should say, we're looking for the following elements. We will take action when we have those elements, and we will follow up with the person who posted. And this is something that you can also find through us or on the Copyright Office. Another thing to keep in mind about the copyright claim is that you need to have a registered agent for receipt of claims. And so you need to register someone with the Copyright Office. It's a nominal fee, but you have to pay money to do this. And I often encourage folks to use a business title instead of a person, because then you don't have to change it quite as often.
And keep in mind, too, with takedown policies, we're talking about what should be in that policy and how does it get communicated. It also goes without saying that if you have a takedown policy, you need to abide by it. If you have a policy and you get notified of something and you fail to take action on it, you can then later become effectively the publisher of that and be held for some sort of contributory liability, whether it's contributory copyright infringement liability or contributory defamation liability, invasion of privacy, whatever the claim may be or claims. You need to be sure to follow that on a consistent basis.
And just to clarify something, I've been talking about defamation and copyright. You really need to have a standalone policy statement for copyright because that's what the law requires. For defamation claims, it's more appropriate to basically have a statement of what is permissible content and what is not, and just have a more general contact us if something you deem to be harmful to you appears on our page that we control. With defamation, you want to show that you had some limited involvement in the publication distribution, but there are actually fewer rules for how to go about following up on a complaint or a claim. So in that case, I think you can get away with listing things, having some ability to restrict access if necessary, and at least providing notice for people to contact you.
Yeah, question here. Yeah, well, let me repeat the question. So the question is, we had said earlier under the work made for hire doctrine that everything that an employee creates within the scope of his or her employment is automatically owned. The copyright is automatically owned by the employer. So what happens if and when the employee leaves the employment? Does that copyright go with the employee? Short answer is no. It stays with the employer. The employer owns that in perpetuity. The employee, despite the fact that he or she may have been the one that spent countless hours and effort writing it, actually has no rights to use that whatsoever. And you want to be in a habit, if you do decide you want to let that employee use that for whatever purpose, as a writing sample or in their connection with their own consulting business or something else, to make sure that you license that. You get something in writing, a license agreement saying we're going to give you the right to use it, but only for XYZ purposes. Even here at Venable, when lawyers leave, we retain the right to those articles that they wrote. I just found something on our website this week that was written by one of your colleagues in the employment group who left, and we're figuring out how to repurpose that and maybe build it into a new article. But the firm owns the right in that. AJ, a related question for you, and this has come up in the past. We were talking about getting volunteers and others to assign the copyright for all of their contributions, so like listservs and chat rooms and things like that, over to the nonprofits that the nonprofit can own. That's easy to do when it's an electronic communication service that is owned or controlled by the nonprofit. But when we're talking about things like Facebook or LinkedIn, and it may be the nonprofit-sponsored page there, but it's certainly not a network that is controlled by the nonprofit, how does the nonprofit, if it wants, say, to secure copyright ownership of the content that's posted by members or donors or supporters on the nonprofit's Facebook page, can you give any practical tips or suggestions? I know there's no easy way to do this, but to kind of transfer that copyright ownership over to the nonprofit.
Sure. Let me just follow up quickly on the other question. Remember that ownership and right to use is dealt with under copyright law under that doctrine, but attribution, who the author is, it still stays and runs with the work. But it's possible that the author may not have a right to use. Now, to his question about what rights can you claim or take, particularly ownership rights and things that appear on your Facebook page, this can be pretty tricky because Facebook is taking some rights, not necessarily of ownership, but in all the content and materials that appear, they're taking at least a licensed right. And so you are not going to be able to stop Facebook from claiming that right. So having some kind of statement that says that the contributor, poster somehow assigns all the rights to your organization, it isn't going to work because Facebook already has certain rights to it. If you have people who are contributing things that you want to have some separate and use of outside of the Facebook page context, then my recommendation would be to take that assignment discussion and agreement offline through some other arrangement. If what you're talking about is something that is really only going to be used within the framework of your social media page, I think you can get away most often with just a mere license. You're not necessarily looking for ownership here. You're just looking for an unfettered right to use. And so simple license can simply be a part of a statement that gets splashed somewhere as a part of your terms of use. I mean, it's more formal and obviously more obvious when you have some kind of agreement, but that's not the way these things work. So at a minimum, you want to take permission through license, but if you really want to own the work, then I would suggest that you take it offline because the context in which it's being posted within a network already is problematic because of the network operator's rights.
And remember, of course, that a license for a nonprofit in many instances is just as good as ownership. For the purposes that nonprofits want to use a lot of the content, if you have a broad, unfettered, royalty-free, worldwide, perpetual, irrevocable, non-exclusive or exclusive license to use the work, that may be just as good as ownership. But again, you need to get that in writing. You want it. I mean, you technically don't have to for licenses. They can be implied or verbal, but you really want to do it through a click and accept feature as part of your terms of use. It doesn't have to be anything that's overly burdensome or legalistic, but it is very important to secure rights from all of your contributors, volunteer, paid, and otherwise. Any final burning questions?
Follow-up question, if you want to use a logo and you want to get permission, but it's a big organization like Salvation Army or something like that, how do you go about getting permission?
You want to repeat the question?
Repeat the question.
Yeah, so the question is, how can our nonprofit go about using other entities' logos under the fair use doctrine without getting permission? And if you determine that it's too risky or you don't want to do it without seeking permission, how do you go about getting permission to use that other entity's logo?
It's a bit of a subjective analysis each and every time. So it's a difficult concept to define with broad rules because the context always changes. But when the evaluation is made, it's always made in a way of what, when, how, and whether or not you're going to make any money off of it. The easiest example of permissible fair use is when you're making a factual reference to something that happens to be called the trademark. So if you want to say, we have a page on Facebook, Facebook is unquestionably a trademark, you can use it in that context. However, if I make that same statement and apply it to some other type of advertising, come see our page on Facebook so that you can sign up for our program event. Well, then we're beginning to change things a little bit, and there might be some indirect commercial gain from using Facebook's name and trademark to further your message. And so we're always wary of telling people what is and isn't fair use because it can really change, but factual references unquestionably qualify, and there are other instances too, parodies and other. So there are times when it's appropriate, but you really got to evaluate the circumstance. And you had a follow-up question about when and where. Trademarks are touchy for some companies, particularly companies of brand. I mean, you can go to their website and see if they have some opportunity for allowing people to use their name, but by and large, that's going to be difficult to find. But, push comes to shove, you can get in touch with their legal department through some mechanism. We might have contacts, et cetera. So if you really want to use something in connection with a more public use, and program events tend to be something where people create T-shirts or things with other names on it. At that point, you can, ask us or ask around, see if you can get in contact with somebody. If you go through the trouble of explaining, in particular, a very limited in time usage, we're making 50 T-shirts, no others, it's only for this purpose. Sometimes people are lenient, and they won't require you to pay money or agree to a written license agreement.
And one comment, something you need to be very careful of. There are very serious restrictions and prohibitions on implying affiliation with or endorsement by some other person, entity, corporation, brand that doesn't exist. Federal laws like Section 43A of the Lanham Act and other statutes strictly prohibit that. So it's very important that you don't use other parties' logos, brands, names, etc., to imply some sort of affiliation that doesn't otherwise exist. Otherwise, you may be buying yourself a lawsuit. Let's take 2 more questions. Yeah, I think over here. There's one. Okay, so AJ, the question is, what sort of right do we have to use testimonials, endorsements, positive praise about our programs, activities, conference, whatever, that might have been posted on our page, posted on our Facebook page, something like that? What rights do you have to use those testimonials, endorsements, with or without certain permission?
Some of this is going to be a function of how the social media network operates. I mean, Twitter hashtags, that's a touchy one because that's pretty much how Twitter works. But by and large, what the law is looking for is some explanation of the connection and the context in which the testimony has been made. So if you're simply grabbing something from somewhere else and it's not merely reusing a hashtag so you can redirect, so to speak, or link back, but you really want to pull the testimony out, separately display or post it, it is useful to provide some notice of where it came from so that you can at least explain to people the factual background for when the testimony was made, by whom, so that it's not considered to be false in some way. Now, I think what you're describing to me largely isn't going to be built around advertising for some product or service. So most of the concerns here relate to that type of usage. But still, you want to make sure that you're being factual how the testimony was created, because what attorney generals and the FTC would be after sometimes would be instances where the testimony is intended to look like it was objectively made about you, but really wasn't.
And sometimes it might be used in advertising. You might want to put a testimonial on next year's, conference brochure that you're promoting attendance at the next conference, things like that, webinar. So, if all else, the safest conservative route is go get permission.
Right.
What AJ is talking about is how can you do that without getting permission? Actually, we had one comment from the webinar, back to your question over here. He said, don't assume that when you go to seek someone's right to use their trademark that they're going to say yes. And that's something to keep in mind. Some organizations, like AJ said, are very guarded about trademark uses. Sometimes you may actually want to consider, can we make a fair use out of this without having to seek consent? Because if we go seek consent, we're likely going to get a no answer. But fair use in the trademark context, fair use in the copyright context, they're both very different. They're both very narrow doctrines. Don't rely too heavily on the fair use doctrine. Right here, a question. So the question is, what sort of restrictions are appropriate to put in? You're representative of a school. What sort of restrictions are appropriate to put on, I presume you're talking about your employees and who they can send friend requests to. Clearly you're going to say don't send friend requests to our students. I don't know what age students, but maybe regardless you don't want to have your employees being friends with the students, although we know that happens all the time, especially in the higher education context. But then you're saying maybe with parents as well there could be restrictions. And your question is, what right do you have to impose those sort of restrictions on your employees?
I'll answer. I'm going to provide sort of quick opinion, and then I'm going to have Ron weigh in because the issues that could be in play here are really going to vary. In a school context, children under the age 18, you're going to have issues communicating with them from the get-go. And the issue is not even what you're thinking of, because it's going to be, where did you get the child's contact information in the first place? Putting aside reaching out and communicating with them just to friend them. And so you need to think about where the information came from, who the intended recipient is, and then for what purpose. But I'm going to have Ron talk a little bit about, let's say that it is somebody that you lawfully obtained their information, and can you create some kind of friend policy? I think it's beginning to be a little touchy about who they can fraternize with, but I'll let Ron talk a little bit about that.
I will start with the proposition that I'm not aware of any legal guidance per se that creates a clear line. I think it's more an area of judgment, and that gives you a lot of leeway. I was sort of struck by when I got up this morning before I came down here, I was listening to the news, and a teacher in Harford County has been arrested and is going to be prosecuted for having an illicit relationship with a student that started off with them friending. And so that's the obvious sort of one of the concerns. There's a lot more concerns. And then what access that person might have. There's a lot of people I know who have policies like that prohibit teachers from friending students, particularly students below 18 in age, and parents. I think it shows a lot of bad judgment to sort of cross that line, and I would tend to do it that way. I can't say that there's anything that explicitly says out there that there's any guidance that says that you can or can't do it. I think it's a difficult question, and it becomes what is the message that you want to send? What is it that you're doing? I mean, I think it's pretty easy to say don't friend small students. I don't think I think that's a pretty simple one. Their parents, it becomes a little bit more difficult because they're going to be friends.
Try and steer the answer back to in furtherance of your organization's mission.
Right.
So if the friend request has nothing to do with school, you may have already drafted the policy statement right there, which is don't do it. If there is some other reason for the friend request that has something to do with your school's activities, then you can sort of create the opportunity for allowing that to happen through, we will be collecting your email address or your social network account for this purpose. We will reach out to you to friend you so that we can communicate with schools. We've been seeing a lot of people within classes want to communicate through Facebook, and they want to create friend groups built around the class. I mean, you need to have a policy that says we're going to take in the children's information with the consent of the parent or guardian, and then we're going to reach out to you for that purpose. But if it doesn't fit within that context, then I think the easiest answer is don't do it.
I just wanted to follow up quickly on that. You were talking about it largely in the context of the teacher friending the students or parents, but in my experience, typically those requests come from students or parents. Would your answer change at all in how you do it that way?
No, I think.
So the question was, what if the request, which may be more often the case, the friend request is coming from the student or parent, not from the teacher?
Yeah, to me, it doesn't matter which way it's coming. It's the very issues that AJ and I've talked about. I think it's a bad idea.
Okay, one final question in the back of the room there.
When an organization is trying to create a corporate contributor account, for example, on a network that does not allow accounts except by a real human being's name, is there any guidance for that? For example, Facebook always still does require that it be a real person's name. So if you're going to create a corporate contributor's account from Office of Communications, Facebook will immediately delete that account. Is there any guidance on how to handle that situation?
AJ, you want to repeat that question?
The question is what do we do if we want to create a social media network account using a corporate identity as opposed to a personal identity? I think in this case we've stumbled upon an instance where the network operator policy has a rule that you need to comply with. I mentioned that when you're creating policies, you need to follow what the network operator states because you're a member of that network. And in this particular case, given some other guidance you've heard about maintaining control, using the entity's own information and account status to sort of maintain that control, I would probably suggest that you create the account under the name of the entity, but if a name has to be given, then the name is given. But this would be an instance then where it's a company or an entity account, and so the company would have the ability to easily go in, take control of the account, change the name, claim control of the account's, contact lists, etc. So the initial creation of the account is done under the auspices of it being part of the entity's account status, but for purposes of satisfying Facebook's rule, a personal name needs to be given. And so in that case, you need to give a name. And the reason they do that is to stop people from creating accounts for spamming or other advertising purposes, or usually if it's not really real, then there's other avenues for causing trouble.
One follow-up question there, AJ. This is something you and I have dealt with quite a bit for clients. A lot of times we see that initially when a social media account gets set up on behalf of an organization, the organization setting up an account, as we just talked about, there has to be an individual who sets it up. We've had issues of once that employee leaves, or that once that employee becomes disgruntled, and the employer, the nonprofit, wants to kind of take back over control of that account, but it may have trouble doing so if it doesn't have appropriate passwords and things like that, or authorization. In fact, we've dealt with this. I'm sure you both have. Any practical tips on proactively what to do at the outset to try to prevent those problems from happening?
There should be an official communication that the account is being established on behalf of the entity. It's really no different than establishing a business address that happens to be entitled to a specific person. Where there have been problems is where you simply designated, or an entity has designated a person, go, register for this, sign us up for here, take control of the account, and they give a lot of control to the individual without much guidance on how much control that establishes that account in the name of that individual. So in this case, if you say we want to have a LinkedIn page, then it should certainly be set up in the name of the company, but you're probably going to have a person control it, but they should be told that they're setting this up on the company's behalf as a part of their employment duties. They're not setting it up in their own name, and there should be an understanding then that when you are establishing accounts, so the policy is when you're establishing accounts on behalf of the entity, we will tell you, and you need to understand that this is an account for the benefit of the entity, not for you as an individual.
And you're going to want to maintain control of passwords and things like that, which will further reduce any legitimate expectation of privacy. The analog in the private industry, if you have people who are using lockers or computers and things like that, typically you want to know what the combination to the lock is or what the password to their computer password is, so that you can do your monitoring, and you can also diminish any claim that that is theirs and that they have greater rights than they might otherwise have.
Okay. Thank you all for sticking around for the extra 15 minutes. We've got about two-thirds of the webinar participants stuck around as well. We appreciate that. Thanks, AJ and Ron, for a terrific presentation. I want to commend your attention. There's a lot of great articles in the back of your handout materials by AJ and Ron on these topics that have more details, and all of you will get a copy of that by email tomorrow. Thanks again for participating. Hope to see you back here next month.